This past Tuesday, the Prime Minister finally awoke to a crying injustice against victims of crime. In question period the other day, he admitted that, I quote, common sense has prevailed, end of quote, on the David Chen case. Yet it was the Prime Minister's inaction and delay that caused and continues to cause victims like Mr. Chen to suffer at the hands of criminals and then, all too frequently, at those of the law, because they are viewed as having infringed the Criminal Code, Section 494, respecting the rights of citizens to arrest. Compliments to Mr. Chen and other victims who challenged the law and the justice system at personal expense, I might add, because they believe that if the law doesn't work, citizens sit, and that their elected representatives need to listen and to act. Malgré le courage, la persévérance de victimes comme M. Chen, l'appui d'autres citoyennes comme le Victims' Rights Action Committee, qui a voulu rechercher et offrir des solutions, le Premier ministre n'a ni agi ni accepté leurs suggestions. In fact, the Victims' Rights Action Committee attempted to speed things along by seeking and researching studied legal opinion on how to amend Section 494 of the Criminal Code. Indeed, initially, this was an acceptable approach, and the results were acceptable to Conservative MP Bob Decker, now Parliamentary Secretary to the Minister of Justice. He committed to table a private member's bill and to send the wording of the legislation along to the Minister of Justice a year ago. That, too, went nowhere. The Minister of Immigration, Jason Kenney, 14 months ago visited David Chen during a photo op and recognized him as, and I quote, a victim of crime, end of quote, and vowed to raise the issue in Ottawa with his colleagues. He also stated, and again I quote, that property owners have the right to use reasonable means to protect their property, end of quote. But again, hollow commitment. Seeking legal advice, the Action Committee came up with a solution to capture the minister's assertions that the merchants ought to be able to use reasonable means. They examined constitutionally sustainable wording. They confirmed their work with professors of law Sanjeev Anand at the Faculty of Law, University of Alberta, and Alan Young at Osgoode Hall. Their solution, again, fell on deaf government ears. Last spring, a constituent of the Victims' Rights Committee contacted me and shared the research and the solution to amending the Criminal Code. She asked that I table legislation to demonstrate to Canadians, new and established, that the law can be changed to correct an injustice. On June 16th of this year, 2010, after consultations with the House of Commons Legislative Services Branch, I introduced Bill C-547, an act to amend the Criminal Code, bracket, arrest by owner, end of bracket. The bill would amend Section 494.2 of the Criminal Code and create flexibility in the issue of citizens' arrest. I think that the court decision in Mr. Chen's regard validates my Bill 547. Clearly, the Prime Minister now must think so as well. He has promised to do what his Minister of Immigration promised over months ago. Prime Minister, I and the Victims' Rights Committee have done your work for you. If the Prime Minister's words in the House have any value, then he should adopt my bill, introduce it as a government bill, and fast-track it through the parliamentary process. Citizens, the courts, and MPs are already in favor of this solution. Will the Prime Minister commit his government's resources? Will he adopt my bill as a government legislation today, or will he continue to delay and victimize victims twice? Thank you.